Let's see, Mr. Bourgeois.
Yes.
Okay.
Good afternoon, Your Honors. Travis Bourgeois on behalf of Church Mutual Insurance Company, SI. Thank you for hearing us today. As the panel knows, this is a hurricane damage and insurance loss case. The case was tried before a jury several days in Lake Charles. A jury verdict was rendered, a judgment was rendered, casting Church Mutual in bad faith. And we have appealed. We have asserted multiple issues on appeal. In the brief time we have today, I would like to address three issues with the court. And the first is the trial court's error in allowing the plaintiff to call a rebuttal witness at the close of defendant's case. The second issue is the trial court's legal error in finding the Church Mutual policy ambiguous, which allowed an award which is admittedly 20 to 30% higher than it should be and affects all portions of the judgment. And thirdly, issues surrounding the erroneous award of bad faith against Church Mutual. The first issue I'd like to address is the error in allowing a rebuttal witness. This case was tried before a jury. Plaintiffs presented their case in full. In fact, they called 8 witnesses. All witnesses testified exhaustively. The defense put on its case, and one of the central components of the defendant's case is that the interior damage in the church was not caused by a hurricane-caused loss, in other words, a puncture in the roof which allowed water to drain through, but it's
we know the facts. So expert Gonzalez said no exterior, no roof damage.
Perfect.
But then he did add his coloration, which I assume wasn't in his report, but you'll correct me if I'm wrong, that this is the worst he's ever seen. It was as if it was raining inside.
He did add the words.
Once an expert witness does give that type of characterization, is it an abuse of discretion for the trial judge to say, okay, we'll hear the guy who serviced the HVAC system?
Our contention is it was an abuse of discretion in this case.
Yeah.
And that's following this court's decisions in the Morgan and the Rodriguez cases, where in order to call a rebuttal witness, the issue must be entirely new and not anticipated. Now, regardless of the use of the term raining inside of the church, which was used on one page of the testimony in 3 lines, the church fully knew and anticipated. It had deposed Gonzalez and had his report that his opinion was the faulty HVAC system was condensing.
That's one thing. It's another thing for the guy to say, in my expert opinion, this is the worst I've ever seen. It's as if it rained inside. How could it be an abuse of discretion for a judge to say, well, we're going to now allow them to say the guy who serviced it said it wasn't raining inside. You had free access to cross him. What was his name?
His name was Daigle.
Yeah, so Daigle drives in and you got full access to cross. Where's the abuse of discretion in that?
The abuse of the discretion is what should have taken place is what actually taken place was a cross-examination. And to cross him on his deposition and say, you never said this in your deposition. In fact, when you look at the testimony, you'll see that the cross-examination takes place over about 8 pages as to the raining issue, where plaintiff's counsel herself, with due respect, keeps saying, it's raining inside, it's raining inside, it's raining inside. So they actually called this to the attention of the jury and then later came back and said, this is a new issue. Cross-examination was the proper thing here. And the reason why cross-examination was proper, because, as you said, Judge Higginson, that the issue was known before trial. We've demonstrated in the brief that it was raised in the opening statement. It was raised in the testimony of each of the plaintiff's 8 witnesses. They elicited testimony as to the supposed defective HVAC system.
Remind me again, what's the harm in allowing a rebuttal witness that you have full opportunity to cross?
The harm in allowing the rebuttal witness is this: the last witness the jury heard after the defendants had presented their case and had no other opportunity to present any other evidence whatsoever. So the last witness the jury hears tells the jury their opinion is entirely unsupported.
Or he just says, this is my personal knowledge. I went there and I serviced it, and it wasn't, a tropical jungle inside. And then you can cross him. Anyway,
Judge Higginson, I
You appreciate-
would have to disagree with you.
No,
and
that's
say we
fine. And
didn't
of
find it.
course, I'm going to ask difficult questions. This is just try to understand it.
Sure. And
That issue is evidentiary. I take it you're going to say the second issue, the actual cash value issue, is a legal error,
this is a legal error.
even though he stopped a witness from talking.
I'm going to say it is both a legal error and an abuse of discretion in his ruling on sustaining the objection. So I think it's kind of twisted. It's an issue of
The objection was a
lines.
403 objection. This will be too confusing. The jury's going to have the policy anyway. They can come to whatever conclusion they have on the policy. Is that? And then he said, yeah, I think that's fine or not.
No, the objection was, and I'll get into it,
Yeah.
the plaintiffs actually elicited the testimony on the issue before they raised the objection, and then they raised the objection during defense cross-examination of their same witness on the same issue and said, no, the policy's ambiguous. You can't ask questions about that.
Let's say you're right.
Yes.
Nothing restricted Miss Davis, and in fact, in closing, she started out by saying it's the time of the incident, and that's what the policy says. So even if there was a mistaken ruling, I guess my questions are two. Did Miss Davis, on behalf of your client, get up and remind the jury it's the time of the incident, number one, and number two, I take it you agree the policy is pretty clear that it is that too.
I'm pretty clear that it is what?
That the valuation would occur at the time of Hurricane Laura.
Oh, yes.
So
Okay,
where's the
well,
harm?
The first answer to your question is, once the ruling was sustained twice as to two witnesses, we were completely precluded from cross-examining any witness or questioning our own witnesses on why their valuations were incorrect. That was off the table. The jury never heard that. While it may have been mentioned,
I thought Mr. Wiggins, they said Mr. Wiggins, was Wiggins your witness?
Wiggins was called by the church as the first witness.
Your witness?
Actually, our corporate representative, but he was called as a church witness.
Okay.
Yes.
But didn't he say the valuation is at the time of the loss?
He did during their examination of him. And when we were going to call him in direct, we were going to get deeper into that. But at that time, and prior to our calling him on our case, the objection had been made and sustained twice, so we couldn't enter that anymore.
Did Mr. Brasher or Ms. Kothari in their closing double down on this point? Whereas Ms. Davis did say to the jury, what you have in front of you is valuation at the time of loss. Did opposing counsel capitalize on what you say is an error? And I'm sympathetic to what you're saying, but I'm asking you a question. Do you recall in closing whether they...
I think this was all wrapped up into Mr. Spott's testimony about all the horrible things Church Mutual did, including trying to pay too little on this claim, which was then used during the closing argument, which said, oh, Church Mutual was so horrible and they did everything wrong, and you heard from our experts how they did everything wrong.
Okay.
So yes, they did use it to their advantage.
Okay.
We've cited, I don't need to go back into the briefs, but we've cited multiple cases saying that this policy language is not ambiguous. So we think it's a legal error.
The jury had the policy.
The jury had the policy, and the plaintiffs offered the policy. They made nothing in the pretrial statements to indicate that they found any portion of the policy ambiguous or to raise the issue. In fact, they questioned two of their witnesses, Mr. Bunn and the church's representative, on the meaning of the phrase. So there was no indication whatsoever that this policy ambiguity was going to be an issue.
I guess the point, you see what I'm getting, he on cross, the judge says, this is 403, it's too confusing. Maybe that's a mistake. The question is it harmless? And if Wiggins still said to them, what you say is crystal clear in the policy, jury had the policy, then Ms. Davis says to them, that's what the policy says. You see my point, it's a harmlessness question.
I see your point, and it's not harmless. Pardon me. The ruling that was actually made was not unduly prejudicial. The ruling that the trial court made is there are different words used in the policy, so this policy is ambiguous. I'm putting it in favor of the insured. So it's not an undue prejudice. The jury will be confused by this. It's simply a flat-out ruling that this policy is ambiguous. And you cannot ask any more questions about it because they win. It's a confusing little portion. It's about 2 pages of the transcript.
I have your argument, because the bad faith issue is a question of Louisiana law.
So, yes, I see where you were going. And we argued, no, the policy is clearly not ambiguous. We argued this again in the motion for new trial. We cited the cases which show that it's not ambiguous. And the reason why it's important is because Mr. Spots, their witness, admitted that by using prices a year and a half after the storm, it's 20 to 30% higher than as of the time of the loss or damage as the policy requires. And this hits not only the damage award and the acceptance of the plaintiff's estimate awarded by the jury, but it also is multiplied in the penalties and is the basis of the attorney's fees. So that legal error alone interdicts the entire judgment. We think a reversal is in order and a remand is in order with a new trial with instructions that the policy is not ambiguous, get the pricing right. The third issue I'd like to discuss is the bad faith issues. There's no bad faith with respect to the first proof of loss, the first inspection that was done. Church Mutual sent out Mr. Montano, who inspected the property, asked for the church and the contractor to be present during the inspection and explain their damages. No one ever showed up. He attempted to recontact these people. No additional information was supplied whatsoever. So Mr. Montano submitted a final report to Church Mutual saying, these are the damages. Church Mutual paid that within 30 days.
But he had submitted an initial report.
He did send an initial report.
You're over the 30 days, correct? If that counts.
If being the operative question here.
Right, but then the jury instructions did tell the jury, unobjected to, according to both briefs, that an estimate was all right and it didn't have to be in a formal form. So why isn't that putting your client on notice that you've got to respond within those 30 days from the initial report?
The charges talked about adequacy of the proof of loss, but they did not say, as far as my reading of them, and I could be correct or incorrect. If I am, I'll notify the court. But the jury charges did not say inspection constitutes proof of loss. This is an issue and an argument raised in the appellee's brief.
Okay.
The charges merely told
that it had to be from the insured.
Right.
Did you ask for an instruction on that?
We did not ask for an instruction.
And
but our argument was in directed verdict that they have shown no proof of loss. So this was clearly our position through this. They have given no proof of loss because they haven't given us any information at all. We relied upon our own inspector. There was no disputed evidence of any greater damages than what our inspector told us was due. So we paid that. That was the only proof of loss, if it was a proof of loss. Now, I've made an entire argument in my brief that revisions to the statute say that the proof of loss must be in writing. And the only written proof of loss was given on May 25th, 2021, long after the first inspection, so 9 months after the first inspection.
So is there a single Louisiana case, and maybe draw your focus to the one that the 28J letters have been discussing, Guillory, that talks to us about satisfactory proof of loss, when, by whom, and what contents?
They're entirely wrong, these cases, and our response to that letter brief, I apologize, I could only file it yesterday. I will tell you why they are wrong. This is the Louisiana Third Circuit Court of Appeal opinion. The Louisiana Supreme Court has never directly spoken on the system, on the issue. But bad faith is a penal statute in Louisiana, and it is worded clearly. And it's in the brief. It was revised in 2019.
Let me just understand, since your time's running out. You're still saying Guillory, where it was an initial report of an adjuster's inspection,
is incorrect.
It's just wrong law.
Is incorrect. It's based on old law. It's based on pre-revision statutes.
What Louisiana case would you point us to that states that it's incorrect.
I wouldn't point you to a case. I point you to the statute itself.
All right.
And had we been before Louisiana Supreme Court, we would be making this argument. But using your powers under Erie, you know that the Louisiana Supreme Court would apply the terms of the statute as written. A revision means something. Addition of new words means something, so you can't read it out. So the inclusion of the word written proof of laws has to mean something. An inspection alone is no longer good law. It's law from the 60s and the 70s.
You still have rebuttal time.
Thank you.
Thank you. Ms. Kothari?
Thank you, Your Honors, and may it please the court. I'd like to spend a little bit of time on the facts of this case. I understand that you have the facts before you, but the crux of their argument as it relates to bad faith is so determinative on the facts, and we have wildly different accounts of what happened in this case. This was an unprecedented Category 4 hurricane that struck this church. It was the strongest hurricane to hit the state of Louisiana since 1850. The record reflects that the church sustained winds of 90 to 100 miles per hour. And as counsel noted, this was a jury verdict. After 4 days of trial, the jury chose not to believe their experts, chose not to side with them, and side with our experts instead, and for good reason. The crux of their argument is determined by if it was manifest error or clearly erroneous for the jury to find that they were arbitrary, capricious, and without probable cause in finding that the initial payment of $4,138 was late, and also if the additional award that the jury awarded of $223,000, they were also arbitrary and capricious. And
It does require both. It has to be late plus arbitrary, and the lateness depends on less your strong rebuttal argument where you did prevail in front of the jury on the sort of blame the pastor theory, but here just the legal question of can an initial report that's this informal count to start the clock for the insurance company?
Yes, Your Honor. And as you correctly noted, the Gilroy case directly stands for that proposition, that a personal inspection can count to start the clock for
I was just going to ask one hard follow-up, because that is a 28J. What was your best case before that case got issued by the Third Circuit? Yes, go ahead.
Yes, Your Honor. It's cited in our brief, the Louisiana Bag case versus Audubon. It's a 2008 Louisiana Supreme Court case, which the Durio case, which is cited by appellants in their brief, also states that Louisiana Supreme Court is the ultimate arbiter of the meaning of these statutes. I would like to bring up in full candor to this court that there is a Fifth Circuit case that is directly on point. Neither side has cited it in our briefs, but in preparing for this oral argument, I did find it. It's the ANCO versus National Union Fire Insurance Company, 787 Federal 3rd, 276, 2015. It specifically talks about this section, 22-1892.
In the future, if you find it preparing, if you submit it 28J, they get to prepare, but they didn't. So we'll look at it, but maybe don't elaborate on that now.
Yes, Your Honor, I understand, and I only found it last night, so I apologize to the court. But the Louisiana Bag case is still good law in Louisiana, and it specifically states that it is a flexible requirement, that they have never applied a stringent sort of strict penal interpretation that appellant is urging. And it's a little bit confusing as to why the 6 or 7 cases that we have cited are not good law in appellant's view. Essentially, it boils down to that the statute was revised in 1990, and even though there's been about 20 cases since then, they think every single one of the cases is wrong.
I'm never good with hypotheticals, but is the logic of your position that the homeowner or here the pastor, the day after the hurricane could say, I've suffered at least $1 injury in an email, and that starts the 30-day clock?
That is not my position, Your Honor. My position is exactly what Louisiana Bag says, is that once the insurance company has an opportunity to be fully apprised of the damages, in whatever form that is. In this case, I would argue it's 2 times. One on September 14, 2020, when the church called in and specifically described the damages and said, our roof is damaged. We believe the structure has shifted. We have a lot of interior damages all throughout the church. The brick is leaning. The shed has collapsed. He was very detailed in this, and this was confirmed in writing. So to the standard that they are urging, It was confirmed in writing by their own adjuster in their internal claims log notes. So that's one that we could argue and find. The second is when their own adjuster came out through a personal inspection, wrote up an estimate, admitted on the stand, and the jury heard this, that he believed payment should have been made within 30 days. That's in the record. He said that on the stand. He was surprised when we informed him at trial that payment was not made. And not only was payment not made of his full amount, because he thought they should have paid $4,800 and they withheld $700 from a carport, but it was not until November 16, 2020, more than 30 days late. Even their own corporate representative on the stand admitted that the September 25th report gave them satisfactory proof of loss for the facts known to them at that time. So I'm quite frankly
Move to the
confused.
arbitrariness then, because their argument there is they can't have acted arbitrarily if all their experts are saying this is minimal loss. The roof wasn't punctured. This can't have happened from the outside.
Yes. And I think what that essentially boils down to is this court would have to find that when there's a battle of the experts, no matter how unreasonable the experts are, no matter how many things they miss, no matter how bad their inspection is, and no matter how long you go without paying this claim, it's been 3.5 years now that they haven't paid this claim, that you can never be found arbitrary, capricious, or without probable cause. Not only is that contradictory to public policy and common sense, it's also contradictory to Louisiana law. That is not what the cases that we have cited in our brief, starting with Louisiana Bag, and then the lower circuit cases, Agigi, Montgomery, Maloney, B. Bennett Manufacturing.
Our standard review is only for manifest error.
That's correct, Your Honor. It is manifest error, clearly erroneous. And let me explain why there's 3 or 4 good points that the jury heard that I believe clearly support their finding. First, their engineer never went to this property. They had an engineering report that from a guy who's literally never visited this property. He only looked at it in photographs. The Durio case helps support that proposition that that's an incorrect inspection. Second, they buried evidence. They produced to us on the Friday before trial over 800 photographs from their 2 experts, many of which showed that our experts were right in the brick being at a lean and sustained structural damage. And that our only opportunity to talk about it was on cross-examination with their expert, Mr. Gonzalez. It also showed, and this will go to the rebuttal witness part of this, that the AC unit, they knew it had shifted off of its slab foundation when he went out to his inspection. Nowhere in his report does he talk about that. Nowhere in deposition testimony does he talk about that. And he raised for the first time at trial a completely new theory of construction defect. He said that it must have been whoever installed that AC unit, which happens to be Mr. Daigle, our rebuttal witness, must have done it incorrectly. That's a completely new defense that had never been raised before and has nothing to do with an inside leaking HVAC unit. And so...
2 cases, Morgan and Rodriguez.
Yes, Your Honor. I actually think the Rodriguez case helps me a lot more than I realized, and for a couple of reasons. First, the Rodriguez case, both cases deal with abuse of discretion in not allowing a rebuttal witness, so for the exclusion of a rebuttal witness. It's the opposite of what happened here. But the Rodriguez case, basically the expert got up and presented a new angle and a new theory at trial. Similarly here, and it was basically, it's a really confusing case that deals with, honestly, expertise way above my expertise, and it's hard to explain, but essentially, whatever defense they originally had to get out of paying the claim, in that case, they came up with a slightly new exception and a slightly new angle on it. And that's what I think happened here. And the court found that it was error and it was an abuse of discretion to not allow a rebuttal witness to go against that. And that's exactly what happened here. I've explained the construction defect part of it. I want to talk about the severity part of it, as Your Honor had brought up in their opening. In deposition testimony and in his report, Mr. Gonzalez said it would take very little water to cause the type of HVAC leak that he had seen at the church. He also said that it was confined to 2 areas of the church, the sanctuary room and 1 other room. At trial, not only did he say it was raining inside the church on direct examination and on cross, But he said that the attic was full of water, and that is why it permeated the entire church. And so he changed both in severity and location of where this water was coming from, plus added a completely new theory of construction defect. That is why it was necessary to bring Mr. Daigle to court. It was not pre-planned in any way. He had to drive 45 minutes to get there. And the trial court was really good in limiting exactly what he could talk about. He could only rebut these two areas, that it was raining inside the church and the installation of the HVAC unit and the maintenance of the same. So it was very limited testimony. I would also like to note that their objection to the same at trial was a procedural objection, that it wasn't disclosed, that he wasn't timely disclosed. They did not raise an evidentiary objection, and we believe they have waived the same. They never once objected to any testimony once it started, and they did not re-urge any sort of objection. And actually, their cross-examination did not focus on the substance of these allegations either. They didn't really go into his ability to maintain the church. They simply asked him more questions about his years of service and his background and whether or not he was a member of the church.
Why don't you move to the actual cash value?
Yes, Your Honor. As it relates to the final point on actual cash value, I admit the policy is confusing, and that's why we think it's ambiguous. But I want to address two things. One is, appellant has urged in their reply brief that somehow one of our witnesses, Mr. Spots, said that using prices in May of 2021 would be 20 to 30% higher. That is not actually what Mr. Spots said. Mr. Spots said in direct examination that in general, after hurricanes, he has talked to contractors who in general believe that it is 20 to 30% higher because of materials, labor costs, etc. What is fascinating is that their own expert believes that the only difference, Mr. Gonzalez testified on the stand, and this is at the record at 3193, that he believes the only difference between his report and Mr. Montano's report, the first adjuster that went out, who used a September 2020 database, and Mr. Gonzalez used a May 21 database, is the difference in pricing. Well, Mr. Gonzalez's estimate was $8,000, and Mr. Montano's estimate was $14,000. So if anything, the price list used in May of 2021 would lead to a reduction of costs, not an increase. And Mr. Bunn, our expert in the cost estimates submitted by us, used the exact same price list as their expert.
Just for a moment, just we consider a lot of cases, remind me exactly what happened when you began to cross. And you made the objection?
I did make the objection. It was their cross of my expert.
You objected. You had gone into this issue, then they try to correct it based on their interpretation of the policy, and you object saying what?
To be clear, and just a clarification point, Your Honor, we did not go into the issue on direct. We asked Mr. Bunn in general what price list he used, but we did not tie it to the policy. We just said, why do you use that? He is a church mutual adjuster. It should be known, and it came out in the record, that he's been adjusting losses for church mutuals since 2004, including Hurricane Laura cases.
And so because you thought the policy was unclear, you then think this will be confusing, you object, and that's sustained.
Correct.
Okay.
Yes. And I would note that they never made an offer of proof, and they never submitted their own jury instruction, as you correctly noted in their opening remarks. And in fact, they had two opportunities to object to the jury charge. Neither time did they raise any objections to the jury charge. The judge's instruction on ACV in the jury charge was simply what is found in one of the definitions of the policy, which is that you take, the replacement cost value of like kind of material and you deduct depreciation. None of the people in this case, not one expert in this case, not one person who submitted an estimate in this case, has used the price list that they are now urging this court to use. August of 2020, the month and day of the hurricane. Sorry, the month and year of the hurricane. Their first adjuster uses September 2020. Their expert uses May of 21. Our expert uses May of 21. Not one person uses the one that they are urging. So if they're right.
The valuation section does say at the time of loss, doesn't it?
It says that for co-insurance penalty. There are two definitions of actual cash value in the policy. One is found under a section called definitions of actual cash value, and it is silent as to when you actually use which price list you use. The second is for coinsurance, because if you're trying to determine the value of the building, you have to determine it at the time of loss. That's when you're trying to figure out if this coinsurance penalty applies. That makes sense. They kept urging the valuation definition at trial and said, this is exactly what this policy says. And that's incorrect. There were two definitions, and at best, it's ambiguous. And they are right that if it is an ambiguity, Louisiana law says the tie goes to the insured because it's constructed against the drafter, in this case, the insurer. And so we don't believe there was any abuse of discretion. We don't believe, and their corporate representative, Mr. Wiggins, did testify to this exact issue. He told the jury very plainly that I believe the correct price list is at the time of loss in August of 2020. That was.
And then am I right, Ms. Davis doubled down on that?
She did double down on that.
Did you in rebuttal, or Mr. Brasher in principle, make a contrary statement?
We did not. We did not address that particular issue in closing. And so the jury was able to hear testimony through Mr. Wiggins of what they thought, the correct pricing was. But they also heard their own expert, Mr. Gonzalez, say that the only difference between his estimate and Mr. Montano's, and his estimate ends up being lower by about 42% lower. And he even said on page 3193 that he added 25 to 30% more than what the exact price list gave him because he felt like he needed to add more for post-hurricane type of increasing in charge. So if anything, the jury really under-awarded us some damages here because if anything, it's about 50% less if we believe what they're saying about the price list. One thing I would note for this court is I don't think their interpretation could possibly be right. Because if they're right that the policy is unambiguous, then how can it be that they get to use a price list that's sort of close to what the policy says in September of 2020, and we don't get to use a price list that's a little bit later? What's normal and what's industry standard and what the jury heard about industry standard is the fact that when you go out and do your inspection, you use the price list at that time. There are a few other examples from the case that I'd like to bring up just in terms of the facts alone as to why the jury's finding on manifest error could be sustained. But there is one point that I'd really like to make as it relates to bad faith, which is the Supreme Court, the Louisiana Supreme Court in Louisiana Bag actually said that if an insurance company is found to withhold any part of an undisputed payment or any undisputed portion of this claim, then they're on the hook under 22-1892 for the full penalty of the difference of what they paid and what the full award is. And why that's relevant in this case is as it relates to the carport issue. Mr. Montano, their adjuster, admitted that he believed this to be a covered loss under the structures on premises section of the policy. Their own claims handling expert, Mr. Fay, also admitted that he thought it was a mistake that they had not paid this part of the loss, the $718. This alone could subject them to penalties awarded by the jury, issued by the judge in the judgment, but in the jury's finding of arbitrary, capricious, and without probable cause. But we think our case is much better than just the carport alone. They had experts who the jury heard never visited the property, as we discussed, from their engineer. They also had their expert, the architect, say that before he ever went to this property, his mind was made up that he was only going to see minimal damages. And he also testified on the stand that he doesn't really deviate more than 10% from the insurance company's estimates in general. They also heard Mr. Montano say that he did a full and complete inspection, but yet he failed to go into the attic. He failed to get on every roof of this property. He failed to go into every single room that was there. He failed to do basic things like take measurements of the roof, and he failed to do any sort of moisture readings. And on the stand with Mr. Brasher, my colleague, he admitted that he missed damages. Mr. Brasher showed him a picture of the valley of the roof, and he said, oh yeah, I missed that. That's wind damage. I should have accounted for that. So this is not a case of where there's really a reasonable battle between the experts. This is a case of where there was experts whose minds were made up. Mr. Montano even told their contractor, they bring up in the reply brief this issue of, we never got to talk to this contractor. There was a contractor the church was considering using, Mr. Herring, Dathan Herring. Mr. Montano writes in his report that he talked to the contractor. The contractor offered to submit a moisture analysis of this church, of every single area that they believe was damaged. And he said, you can submit what you like, but our mind is made up. We're only covering damages to one room, the sanctuary room.
This is the contractor who didn't show at the very, very beginning.
That's correct. And I would note on that, the pastor did testify, and that there is testimony in the record that the pastor didn't receive a phone call before this inspection was scheduled. To his knowledge, he didn't know when they were coming, so it was a bit of a surprise.
You're late.
Sorry, Your Honor. If there's no further questions.
Thank you very much.
Thank you.
Counsel.
A lot there, so I'll just pick up in the order that it was expressed. We do argue that the jury finding is clearly erroneous as to the bad faith award, and this is why we do it. Let's look at the first report created by Montano. The jury was asked, is any amount owed other than what that was paid, and when was it due? The jury finds that all 230 additional $1,000 in damages were due from Montano's first report when he stepped foot on the policy without any input whatsoever from the church's contractor, the church, or anyone else. We really have to look at a strictly construed statute here to determine whether or not penalties are awardable and if the conduct is truly arbitrary and capricious under the undisputed facts. And the undisputed facts were 3 days after the report, the church retained Ingle Martin. 9 days after that, after making an appointment, he shows up for an inspection which the church does not attend, the contractor does not attend. He has to look himself. He discovers $14,000 in damages, makes a provisional report to Church Mutual. And I do say provisional because when you look at Defendant's Exhibit 4, 5, and 6, which are the initial report, you'll see it's replete with, this is an initial estimate. We are trying to collect more information from the insured who's not being cooperative. So they still come back with only $14,000 in damages. Church Mutual pays that. How is that arbitrary and capricious when there's no competing proof of loss, no proof of loss whatsoever that Church Mutual could have paid, much less $230,000 in addition to that award when the church does submit its first proof of loss? And what does the church do? What does Church Mutual do when that proof of loss is submitted? The next day, finding that $230,000 in excess are alleged, it retains licensed people from Louisiana, an engineer, an architect, and a crew of people to go back and inspect. And they do that.
This point is going to the 30 days or to the arbitrariness?
This is going to the 30 days after the only submitted proof of loss.
But I'm just reading, I think this is the jury instruction you agreed to. The jury was told proof of loss, quote, is a flexible requirement. It is not required to be in any formal style. The manner in which it obtains the information is immaterial.
We would agree with that jury charge, and we're bound with it now, but our argument has always been on directed verdict and here that no proof of loss was made. But even if a proof of loss was made, that's only one element under Louisiana VAC.
Start the clock running, informal initial report. And so then we're just left with, is there manifest error when they look at this entire trial?
There has to be a proof of arbitrary and capricious behavior. What does that mean? That means intentional. That doesn't mean, oh, we made a mistake, oh, we didn't look at something. That means vexatious.
It's a high standard to the jury, but now you're asking us to reverse the jury.
Exactly, on the undisputed facts. What did we do arbitrarily and capriciously? We sent out people immediately. We relied on expert opinions, which we are allowed to do under the Price and the Butler case. We are an insurance company. We send out licensed people to inspect and tell us what we need to do. Those people come back and tell us first, you only owe $14,000. But when the deductible's applied, that only comes out to $4,000. We make that payment. 9 months later, we get the only proof of law saying, no, you owe us another $230,000. What do? We hire experts, licensed experts in Louisiana, whose qualifications were never objected to in a Daubert motion or during the hearing, during the trial. The qualifications were accepted. These licensed experts tell Church Mutual, the first inspector got it wrong. You don't even owe that much. The only damages we saw were $8,000, which is below. By that time, suit has already been filed. Suit was filed 3 weeks after the proof of loss was delivered. We're entitled to litigate this under the several cases we cited. Reed, Gardner, Hedrick, Darby, all of those cases found.
Your time's up. I have one question. Are the cases you cited to us in the rebuttal witness, were those situations where the witness had been disallowed? And if so, do you have a case where it was reversible error for a trial court to allow a rebuttal witness? Two-part question. Were the cases you gave us the opposite?
Morgan and Rodriguez.
I think I cited those cases for the standard of when a
Do you
rebuttal
have a
is.
case where a trial court was reversed for allowing a rebuttal witness?
I do believe that's the McAfee versus McCurry case.
Okay, thank you, Counsel.
Yes, thank you.
The case is submitted. And that concludes the cases for the day. Thank you very much.
Your Honors. We appreciate the long afternoon.
Okay.